It is March 29, 2012. This is Justice Done Dirt Cheap interviewing Sally. How are you doing, Sally?
I'm doing okay.
You were just in court.
I'm a little shaken.
What were you expecting today at your hearing?
I was expecting the designated judge to turn up. He's a judge who I have complained about and filed an appeal against, and he was scheduled and he should have come today to probably recuse himself. What I found when I turned up was a judge who has previously recused himself from my affairs, I have previously complained about, who is very biased against me. He refused to recuse himself, even though he is in a position of conflict because he and I now have personal issues with the complaint. What I find again and again is they do take advantage of self-litigants. They do not help in any way. They're supposed to give direction and they don't. He knows that I'm mentally ill. I do still have a lot of health issues because of harassment I've suffered, and they give absolutely no latitude or leeway for that either. He allowed the Crown to bring a witness. They did not give me any indication. A police officer turned up and he refused to adjourn to give me time to prepare.
I may ask a question. Who was the police officer who appeared today at the hearing?
Staff Sergeant Daniel Kopp, who participated in a complaint procedure. I filed criminal complaints against 4 police officers who forced entry to my home on the 6th of February 2010 without a proper knock and announce procedure, without grounds. They claimed they were coming under the Mental Health Act, and they proceeded to beat me up and arrest me.
So were you given any warning or any advance notice that you would have the opportunity to cross-examine the witness today?
No.
So the Crown Prosecutor did not tell you whatsoever that you'd have the opportunity to cross-examine well,
that's correct.
His purpose today was in what capacity?
He was appearing on behalf of the Fredericton City Police as their, shall we say, guru or advisor on police policies and protocols. What he actually did was just tell the court under oath that the Fredericton Police Force have no policies and procedures at all on forced entry at night time, on forced entry under the Mental Health Act. They have no policies and procedures whatsoever for dealing with situations where the police turn up and they find that there is actually no need for them to break in, but they break in anyway. He said a lot that was shocking, because the police are required under the New Brunswick Police Act, as well as law and international law, to have policies and procedures in place for training their officers.
So today you had someone who is an expert in police policy appear at a hearing for disclosure, which they did not give you any advance notice, so you could not be prepared and have a very strategic set of questions to ask him for the purposes of disclosure.
That's absolutely correct. And I am now required to go back at 2 o'clock this afternoon and present argument. And I said I object to that because I haven't even had time to prepare to cross-examine a witness. I had no idea that we even had to provide evidence. I don't even know what he wants. I don't even know what evidence he's talking about. He said I have to provide evidence for the documentation that I want as disclosure. Basically, the law and common law says the Crown has to disclose everything that even might be helpful or useful to building a defence, and they are refusing to provide anything at all. The Crown Prosecution have also stated in writing that they will not provide me with a public document called the pre-charge review that they're required to complete in order to evaluate whether to proceed with the prosecution. And the Crown's claim was that it comes under solicitor-client privilege between them and the police. The Crown is not the Fredericton Police Force's solicitor. They are public and independent, and their duty is to the public, not to the Chief of the Fredericton City Police. So I'm a little ticked off.
Wow, so the purpose of today's hearing was disclosure so that you could properly defend yourself with against the charges that the Fredericton Police Force have laid against you. Is that correct?
Yes, absolutely.
And the Crown Prosecutor is not disclosing the information that you need for your defense.
I have requested all police reports to do with me. They've refused. I have requested all of the NCO's reports from the night the police forced entry. They've refused. I've requested the Crown Prosecutor's evaluation of why they chose to prosecute me. They've refused. And all we've learnt today is the Fredericton Police Force have no policies whatsoever on anything.
That's interesting. How could a police force operate without police force policies?
Well, I'm going to find out. And I'm going to find out who actually cares, because so far I don't find anybody in authority or in the establishment in Fredericton or New Brunswick who actually cares at all.
Is the Fredericton Police Force required to have policy procedures?
Under the New Brunswick Police Act, the Chief of Police with the City of Fredericton are required to devise, design and implement policies, procedures, protocols for training their officers and to serve and protect the public, yes.
So is the responsibility on any one individual in the police force?
Chief of the Police, Barry McKnight.
Is that according to any particular statute or?
The New Brunswick Police Act. I can't remember which clause it is, but it's the New Brunswick Police Act. It's his responsibility, and he has to make sure that the City of Fredericton approve of his policies and procedures, so the Mayor obviously doesn't care either.
Wow, so if the police have no procedures under these circumstances surrounding the charges against you, then how... It's quite amazing that they acted in the way that they did, because the experience that you had, if you can sum it up in a few words, what was the experience you had that resulted in charges being laid against you, and what are those specific charges?
Well, the charges are funny. What happened was I was a victim of crime, spousal support fraud. 2 lawyers committed fraud against me, my own being one of them, which has defrauded me of now around $50,000 of spousal support. My own lawyer was the ex-deputy mayor of Fredericton. She was the deputy mayor at the time she committed the fraud. She submitted perjured, falsified calculations to the court to keep me and my ex-husband fighting so she could keep earning $250 an hour or whatever she earns indefinitely. I found out the fraud and I told the police about it, and then I started getting harassed by the police. At the same time, I was becoming mentally unwell, and the police used that to break into my house on the 6th of February 2010, late at night, when they claim in their own reports they saw me through my window, talking, acting normally, in no danger whatsoever. They did not knock and announce. They just broke my door down, pushed me to the ground, yelled at me, screamed at me, and then they pepper sprayed me and handcuffed me and carted me off to hospital. During the course of that, they arrested me twice for assaulting them, because they knew they'd exceeded the bounds, and once pepper spray is deployed, they have to fill in a use of force report once a member of the public is hurt. They have claimed in their reports they were the ones who physically touched me. Anyone who touches you without your permission is guilty of assault, and that's what the police did to me, and they ended up charging me to protect themselves, thinking I would shut up about the ex-deputy mayor committing fraud against me, because of course the mayor's office is in charge of the police, and that they would shut me up about complaining about their officers. This has led to now, that happened 6th of February 2010, it took them almost 6 months to issue a summons. They have no powers of arrest under the Mental Health Act at all, and they had no powers to break into my house when they could plainly see me in good health. So the courts have helped the police. The Crown accepted it to prosecute, as they do against many people. They accept charges that are unlawful and they prosecute them, and the judges help them.
Was this a purely discretionary decision for the police to arrest you that day?
Yes.
So they have no actual procedural reason to do it, other than they decided that day based on their discretion?
They only have powers to enter a private dwelling and arrest somebody under the criminal code if they know or are reasonably sure that person is there, has committed a crime, is committing a crime, or will commit a crime. The only other reason they can break in is if there's a 911 call or the person is in imminent danger, which means life-threatening. And not one of those circumstances was in evidence. It was just, they had no grounds whatsoever.
Okay, well, we'll leave it at there. Thank you, Sally.
Thank you.